Imagine it's a Friday afternoon and you've finished your workday. As you close your laptop, you see one more email pop up and you realize that it says Cease and Desist letter. You open the attachment to the email and you see that it's a demand from a lawyer requesting that you stop selling your product immediately. Close the letter and you think to yourself, what do I do now? A cease and desist letter is a written request to stop doing, saying, or using something, typically on an emergency basis. It affects your business because you have to consider stopping the marketing, sales, and progress of a new product or service on an immediate basis, not because it doesn't work, but simply because of the name of the product. What does the typical cease and desist letter say? The sender will claim a right to request that you stop using a trademark because they have superior rights in that mark. The basis for the letter is that the sender believes that the continued use of its mark and your mark is likely to cause confusion in the marketplace. That is, people will be confused over who is the source of the product, the sender or you. It typically identifies the mark and the conduct they want to stop or cease happening, and it typically includes a threat of damages and an injunction, that is, a court order requiring you to stop selling your product. It usually gives you a short time frame to respond, about 10 to 14 days. If you're the unfortunate recipient of such a letter, don't ignore it or throw it away. Instead, immediately forward it to experienced legal counsel as soon as possible. Your selected counsel will evaluate the strength of the claim and assess your risks. Don't assume the other side has superior rights just because they sent the letter. You may have defenses such as, are the trademark rights the sender is asserting valid or enforceable? Do you have priority of use in the name so that you don't have to stop using it? What is a likelihood of confusion, and is it present here? Experienced counsel can go through the multi-factor test that the courts use to determine whether a likelihood of confusion exists. Look at the stated objective of the letter and think about what your own future plans are for the use of your own mark. Is it a fundamental mark to your business, or is it a new brand that you haven't built up significant goodwill in and could pivot away from without too much expense? You want to respond to the claim with a phone call or in a strongly worded, detailed letter. In that letter, your responses could dispute the claim in its entirety. You could also propose alternatives to that, such as perhaps entering a disclaimer of association to help dispel any likelihood of confusion. You could consider licensing the use of the mark from the sender. If you're going to go ahead and stop using the mark, you can negotiate a wind down and transition period so that you have time to sell off the product that's on the shelves at the time and transition to a new brand so that it's as seamless as possible. Still, another option is to file a declaratory judgment lawsuit with the court asking for a judge to determine that you have superior rights in the name or that there is no likelihood of confusion. So, in sum, don't ignore or throw the cease and desist letter away. Don't assume you have to comply either. Share the letter immediately with experienced trademark counsel who can give you advice about your rights and the response that you want to make.